Can start the family law calendar. First case, Richer and Richer, Ms. McLean, Ms. Dow. I assume I need to kick this over till next week for Judge Evans.
Your Honor, I believe that Ms. McLean and I are really close on this, and I'd rather get the order signed so that we can move on here. You can, if you can just hear me out for a moment, perhaps you can decide, and Ms. McLean can decide whether or not we need to move this. As far as the proposed order goes and Ms. McLean's objections, I happen to think that the proposed language in paragraph 1 is sufficient, but I do agree that the language regarding payment for the GAL services should be added. The court did order that. It did not get into my proposed order, and I apologize for that. As far as paragraph 2B is concerned, the language that the judgment for payment to Ms. Eastwood includes interest is also appropriate. That's there in the court's orders previously. I believe Ms. Eastwood is now known as Erin Reitz, and that should be on the record that payment should go to her as Erin Reitz. As far as the proposed language for paragraph 2A, that was not ordered by the court, and it's also moot because my client has already paid for and completed the first steps of an evaluation with the previous evaluator, who is adding the components for a standard parental risk assessment. So that's kind of moot at this point.
Ms. McLean?
So I guess my only concern as it relates to some of the language in paragraph 1 is that it assumes that there's going to be reunification counseling, and that's not accurate. The court had ordered for a guardian ad litem to be appointed, the sole purpose to determine whether or not reunification counseling is appropriate. And that's why I changed up the language. My proposal changed up that language and removed the first part of that. So if you feel that you can make a determination in the vacuum, I'm okay with the court doing that. Alternatively, I would ask that it be set over.
And Your Honor, I don't really object to that language. That is what the court did say. That was the purpose for the appointment of the guardian ad litem. So I don't necessarily object to that.
All right, in reading that language, it looks like it leaves all options open to me. So I think that's appropriate. So in essence, we're agreeing that Ms. McLean's objections and proposed language should be included.
For paragraph 1, yes.
Okay.
Yes. To help us move forward, that's fine.
And then just so I know, so are you indicating that Kirk Johnson is following up with supplementing his report?
Yes. My client has already had his first meeting with him. He's due to come back in to finish up something else. I spoke to Dr. Johnson's office yesterday evening, actually, and hopefully we should have a report more quickly than has been our experience with Dr. Johnson.
And I believe that needs to include collateral input from my client.
Yes, that was part of the order.
So I think that language needs to be included because that isn't, I don't think that's, oh yeah, it does have the collateral input. Okay.
Yes.
Okay, so I'm assuming Ms. Dow is going to make those changes to the order and ship that to me, and then we'll just ship it to ex parte. If we still have difficulties or issues, then we can just note it back up for presentation.
That's fine with me.
I'll strike the matter, and so Mr.
Everything
Powell,
gets
assume it
cut
will
out
be
for a
signed on
minute.
presentation.
Thank
Mr.
you.
Powell,
Thank you.
Ms. Bliss has presented proposed final orders. Are you in agreement with the language in those orders?
No.
What's the issue?
Me and my wife discussed a couple of changes. She had her lawyer resubmit the paperwork. One of the changes was in there, the other one wasn't. And I'm not agreeing to the new paperwork they submitted. It's not what I discussed with my wife.
What's the change that's not in there?
My wife wants to be able to UA and breathalyze me, and I want to be able to do the same to her. And she refuses. I'm okay with her UA and breathalyzing me all she wants.
Stop a second. So what you're telling me is not that there's an agreement that's not in here, that's that you're still not in agreement. Is that what you're saying?
No, I'm not in agreement at all. Yes.
Ms. Bliss?
And Your Honor, looking to the CR2A that the parties had signed and dated in my office, May 23, the only change to my client's proposed parenting plan was removing the requirement for him to obtain a substance abuse evaluation. The language that he's now requesting to change was included in my initial parenting plan. He agreed to enter the parenting plan as proposed in its entirety otherwise. So at this point, I think he is changing the agreement that the parties already stipulated to under the CR2A agreement. And so I would ask the court to sign my parenting plan as it's been presented, as it is consistent with the agreement of the parties.
So does the May 8th parenting plan include the language that appears to be at issue?
Correct, Your Honor. In that parenting plan, all of the limitations that Mr. Powell is contesting now are contained in 4A. There was a 4B section that required the evaluation, and under section 5 of the CR2A agreement, or 4 of the CR2A agreement, excuse me, it says respondent is not required to undergo a substance abuse evaluation as part of this action. This provision contained in section 4B shall be removed in its entirety. Looking to section 5 of that CR2A, the remainder of petitioner's proposed parenting plan as filed on May 8th is adopted.
Mr. Powell, you have that document in front of you?
No, I have it.
Okay, that's what the CR2A says. Section 4 removes the requirement of a substance abuse evaluation. Section 5 that you agreed to says the remainder of petitioner's proposed parenting plan as filed on May 8, 2023 is adopted. So that's the agreement. CR2A agreements are enforceable. So it looks like the proposed orders and findings need to be signed as submitted.
Me and my wife talked and discussed it. She was supposed to add it to where I could UA and breathalyze her too. And then she changed her mind.
Yeah, you were just telling me that that's not agreed to. So we're back to the original CR2A. And like I said, under Washington law, those are enforceable. So if you want to try and change it down the road, you can bring a motion to modify. But I have to enforce the agreement you previously signed. So I will sign that.
Thank you, Judge.
And I have signed those orders.
Thank you, Judge.
No, I can call his office. I did, like I said, I indicated that the court would come back at 10:15 and 10:30. I understand the court's unavailability. I do think that this is somewhat pressing given the issues of this case and the location of the child.
Okay, I don't have anything else on for the morning, so why don't we plan on coming back at 11?
Sure, just so you don't have to keep coming back.
If you can send Mr. Roberts that message.
I will do so. I appreciate your patience.
Okay, and counsel, I've got Mr. Roberts' notice of appearance. I don't have any pleadings. Do you know if there are any from him?
No, not beyond what his client has already filed.
Okay. All right, thank you.
Thank you.
All right. Ms. Gilmore, go ahead.
And Your Honor, this matter is before the court on my client's motion for contempt. I represent the petitioner and moving party, namely Michelle Taylor. There was a final parenting plan entered in August of 2021 that provides 191 findings against father and gives him limited daytime visitation. As detailed within my client's declaration on July 15th, respondent had visitation with a child and refused to return her. Respondent then filed a petition for a protection order on July 19th. Within the order, he fails to name the family law case and claims that to the ex parte judge this child that he has custody of this child. At the domestic violence protection order hearing, respondent asked for a set over to obtain counsel, which he has now done. The court granted that set over, however, directed that the family law issues, i.e., where the child will be placed on an interim basis, would be determined by the family law court at this hearing. As explained within my client's declaration, respondent has a lengthy history of substance abuse as well as domestic violence. Prior to and following entry of the final order, respondent filed a modification request in March of 22, making very similar allegations against my client and her household. That adequate cause finding was ultimately denied roughly a year ago. Following the denial, my client continued to have concerns about respondent's substance abuse as well as involving the child in conflict. The respondent's behavior really started ramping up in July of this year, as detailed in my client's declaration, where he made several reports to CPS that were all unfounded. Again, on July 15th, he then took the child for visitation, texted my client indicating that he was not going to return the child and refused to do so. I think that's even more concerning is the fact that he started to have visitation on July 15th at 9 a.m. He clearly then immediately got on the freeway to go into Randall's hospital, where the doctor's report indicates that the initial notes were made at 11:40 a.m. So there's really zero time for a child to make a disclosure in this case prior to getting on the freeway, violating the parenting plan, and seeking medical care for this child under a case where he has very limited visitation. He frankly shouldn't be leaving the state, let alone taking this child to the doctor. More importantly, within those medical records, the child is reportedly makes no disclosures, number one. Number two, is smiling and acting appropriately. The records also show that it's pretty clear that father became frustrated when the doctors clearly weren't making or didn't find any disclosure concerns, and then asked that they be transferred to a new hospital. At this point, father is just shopping from provider to provider to CPS caseworker to CPS caseworker in an attempt to frankly violate the parenting plan, circumvent the court's current order that provides him, again, very limited visitation. We are clearly frustrated by this process. Again, this child has been in my client's primary care. She frankly has never been away from her mother more than an overnight absent an odd vacation. She's never had overnight visitation with her father. And we have very serious concerns given the recent disclosures of the child to the long-term daycare provider. Frankly, the daycare provider is indicating that the child's making disclosures that actually, in fact, father is the perpetrator of potential molestation or inappropriate touching. So we are very concerned that this child has remained with father for the last 3 weeks, and we believe that the child frankly has fallen through the cracks as the DDO process was set over. We don't know, my client has had no contact with the child. We don't know where the child's at. Father has taken upon himself again in violation of the parenting plan to take the child out of the daycare provider that she's gone to for the last 2 years. So we have zero safety nets in this case to ensure that this child frankly isn't being abused by father, at the very least, manipulated or brainwashed. The situation with the child and the father's care was so severe that the daycare provider provided or reported to CPS that she seemed distraught, tired, and again, reported father touching her genital area. So we do ask the court find contempt, immediately transfer the child back to my client. We can deal with the protection order issues at the next hearing as well as adequate cause, but I think it's extremely vital and time sensitive that this matter is heard and that my client, the child's transferred to my client immediately. My client provides to the court that if the court has any concerns that Mr. Applefield, she's already moved him out of the residence. She denies that he's ever had unsupervised contact with the child based on father's history of making false allegations, both to the court and to law enforcement. And so, but my client is willing to put whatever safeguards in place. CPS is in support of the child being transferred, but for the court order. So we do ask the court grant a motion for contempt or the child is immediately returned to my client and award significant attorney's fees in this case. Father failed to go through the proper remedies. He's again had a history of using the CPS process. And again, this child has fallen through the cracks and is suffering greatly at this point.
Mr. Roberts?
Good morning, Your Honor. We were retained late last week and filed a notice of appearance yesterday. There's a lot here for me to get my head around. I apologize for not being more up to speed, but this is the honest history of my involvement with the case. I understand that there is a DVPO in a parallel case, and there is a motion for contempt on that DVPO because mother was not supposed to have any contact with the child, and she used a daycare provider to interrogate or question the child in violation of that court order. and that is on for a hearing, I believe on August 14th on Monday. There currently is a CPS safety plan in place. Ms. Gilmore says there's no safety net, but from what I can gather, there's a CPS safety plan in place that my clients filed with the court. It extends through August 16th. My client informs me that he was in contact with a CPS worker this week, and they're working on an extension of that safety plan as of today or yesterday. My client also provided me with a declaration from his older daughter, Cheyenne. It's not yet been filed. He has it ready to be filed today, where she's an adult, and she was witness to a statement from the child.
I have to object. That's not before the court. Child hearsay as well as
I understand. I'm going to allow a little bit of.
And I'm not trying to present anything to the court for the truth of the matter. I've been recently on this case with information that I expect to have could file, and it is an argument to put a pause on things. I understand there's been a history. I know Ms. Gilmore's asking for things to happen immediately, and I have to just let the court know that there is a declaration that my client can file soon, where his other daughter states that she was a witness to the child saying things consistent with what my client has presented. My client did share that declaration with me, and as an officer of the court, I can tell you that exists. With respect to Randall, I'm at the timeline and everything is very confusing. My client informs me that Randall was the only hospital with a forensic doctor on staff, and then he's trying to get the records from the second hospital that they took the child to, but that's not available at the moment. But right now we have a CPS safety plan in place to next week through Wednesday. Here's, I don't want to say a probability because I haven't had those conversations, that there may be one that continues beyond that. There's no indication the child is imminently in danger right now. And it would be helpful to my client. His request would be to put this matter over to see what the CPS safety plan continuance is, if one, get more information from CPS at this point, and allow me to have an opportunity to more comprehensively put together a clear packet to address the concerns that my client is raising, and that he denies doing anything in bad faith. He had these concerns legitimately from hearing from his daughter, and he scrambled to handle the situation the best that he could.
Ms. Gilmore?
Just briefly, Your Honor, I think that either father or counsel is confusing a safety plan with a recommendation to transfer custody. I had repeat conversations with the caseworker, Kylie Ward, and there's no recommendations that the child should be placed with father. She indicates that upon the court making a ruling that they would place the child with mother, and then there would be a safety plan in place at that point. I think what's really important in this case is there's no allegations made against mother at this point. So the safety concerns would frankly be Mr. Applefield. My client is telling this court that she has moved Mr. Applefield out. She's willing to, establish no contact with the child and Mr. Applefield. She's willing to do whatever is in the best interest of the child. And frankly, if some sort of abuse had happened in her home, she's going to appropriately handle it. Frankly, again, given the history of father, we think that these allegations are legitimate and there's no actual evidence, no disclosures of the child that are evidenced by the medical records. But I think for an interim immediate order, the child should be with her primary parent that she's lived with for her entirety of her life. She needs to reestablish her situation, and we deal with adequate cause and what happens with the investigation down the road.
All right. Well, what is clear from the history in this case is that Mr. Bailey has a significant history of crying wolf that has been repeatedly shown to be false. In the current situation, rather than bring any kind of motion in this parenting plan case, he filed another action where it appears he lied about who had custody of the child. And when he attempted to have this investigated, at least based on what minimal records we have, it went nowhere. So I'm finding Mr. Bailey in contempt. I'm going to order a full award of Ms. Gilmore's attorney's fees. B, I am striking the order in the family law or in the protection order case. Do you have the cause number of that in front of you, Ms. Gilmore?
I have it, Your Honor. I feel like
Yes,
that's
sir.
helpful. It's 20.
All right, thank you. So that order will be stricken. The matter can be left on for review if necessary on the date that's already set. And the child will be back in petitioner's hands by 3 o'clock today, or there will be a warrant issued for Mr. Bailey. And Mr. Roberts, Ms. Gilmore's been through this before. I am retired. I'm not on the bench all the time. If there are any issues about the order, the easiest way to handle them, rather than having to note up a hearing and set a time to bring me in, is to just handle any disputes by email, if that's agreeable to you.
That's fine, as long as the court's willing to accept email directly, that's fine.
All right. And I think Mr. Bailey wants to talk to you. Mr. Bailey's not going to speak in this proceeding.
Your Honor, if I can clarify just your email, do you have a county email or are you working off your personal email?
Just send it to my personal email.
Okay, I'll circulate and attach
On
all
that
parties.
matter, I see
All right,
Kendra
thank you.
Rapp
That's fine.
present.
All right.
Thank you.
Is Mr. Weaver present?
Jane Woodruff, I'm here, Your Honor.
Good morning.
Good morning.
I think this happened with your microphone last time, so you might have to stay muted until you're the only one talking. Okay, perfect. And then anyone else we're expecting on this matter?
Just me, Your Honor, Sherry Farr, the court guardian ad litem.
Good morning, Ms. Farr. Thank you for being here.
Good morning.
So when I looked back at the last hearing in this matter, essentially where we are is we had extended the immediate minor guardianship. I know there was some issues with contact with parents. I do believe we had set today for a show cause on the emergency guardianship. But I'll turn it over, I guess, you to Mr. Anagnosio first and let me know how you're asking the court to proceed today.
That's my understanding, Your Honor, that we were setting the show cause to enter the emergency guardianship order, and my client's present. I'm prepared to let her testify. The issue is my client was getting visitation, kind of regular visitation, but that's been cut off. She went on. She was out of the state for about a month. She was in Hawaii, and for some reason that's an issue, and we don't think it is. But she should get some contact with her daughter.
Okay. Is she objecting to the emergency guardianship being put into place?
She is.
She is. Okay. And I assume, just based on my limited contact with this case, that we're not expecting Mr. Weaver.
I don't believe so.
Okay. All right. So let's do, since this sounds like it will be a hearing, Mr. Anagnosio, are you guessing about 30 minutes or so?
Yeah, probably.
Okay.
Your Honor,
Go ahead, Ms. Farr.
I don't see how we can do a hearing this morning because I still haven't had an interview with mother. She only called me back last night and left me a message after I emailed her and said, I haven't heard from you. She called me and left me a voicemail this morning. It's been 2 months since I've heard from her. At the last hearing, you instructed her to get in touch with me and she did not. So I don't have enough information.
Okay. So your request as the, do we have you listed as a court visitor or guardian ad litem in this case?
I believe it's the court visitor.
Court visitor. So I think you're fair to say your request as a court visitor would be a continuance on the show cause hearing.
Yes, please.
To gather additional information. Okay, so Ms. Woodruff, I will get your input here in just a second. Let me ask Mr. Anagnosio if he has an objection to that continuance request. Obviously, we'd keep it somewhat short, and at some point, I think the court would draw a negative inference from the mother's lack of contact with the guardian ad litem.
Right, and it's my understanding she has tried to. My understanding is they had a video conference set up that for some reason didn't occur. But anyway, that's fine. We could set this over for the guardian ad litem and my client to communicate. But in the interim, we would like to talk about visitation going forward. My client had visitation, but for some reason, like I said, this vacation, she's gotten back and they have refused to allow her to have contact when prior to this, she had even overnights.
I don't believe that's true. And looking back at the immediate orders, hasn't been any overnights or set visitations in place that I can see.
There was nothing set. It's what the parties were doing.
Gotcha. So let me just go back and quickly look at the very first order that was put into place. And then I'll look at I'm just looking to see if there was any back in March. Doesn't look like anything was discussed at that time. And yeah, I'm not seeing any of the orders addressing it. I'm just looking to see if the prior judicial officer addressed visitation in his hearing notes. Okay, I'm not seeing that. So Ms. Woodruff, before you unmute, what I'm going to do, just because we'll get that echo, is just number one, let me know if you object to set out. Ms. Farr, how long would you be asking for?
I would say 2 weeks because my schedule is full this week and I need to set an hour time with Ms. Rapp.
Okay.
So I would think that I can't get that done till next week, as long as she schedules with me.
Okay. So Ms. Woodruff, we'd be looking at August 22nd at 10:30 a.m. So let me know first.
That's
go ahead,
fine.
go ahead and mute. Okay. First, let me know if that works for you. And then second, if you could just briefly address for me your understanding of this visitation issue that the mother's attorney has brought up.
Yes, so no objection to August 22nd. That is fine, Your Honor. And then as visitation goes, I have both siblings. So I have Brian tendency case, and we, my fiance and I have discussed that we want the visits between both children to be at the same time. We don't think that Shyla should be getting more visits than Brian should be getting. They should be, our interest is for the children. They both should be at the same time. I messaged Kendra because it was a constant every morning message. Hey, what are you and the kiddos doing? Hey, what are you and the kiddos doing? Which is fine because I understand they are her children, but I want to respect our household and it's not every day I can do something with bio mom. So we just said, hey, this is an email. If you'd like to set up visitation, this is the way we'd like you to contact us. It was very respectful. And I guess she took it the wrong way of how I was just trying to respect our home with her home.
Okay, here's what I want to do. And just to be clear, I did see that the younger kiddo has the dependency case. Shyla not involved in any sort of dependency actions at this time, correct?
Correct.
Okay. So what I want to do, I do think the visitation issue is important. What I'd like to do is set this out for 2 weeks. Because we haven't had a hearing on visitation, I don't have enough input from Ms. Farr because of mother's lack of contact with her to make a real intelligent decision about what visitation should look like. That to be part of our hearing on August 22nd, So we'll be addressing whether or not the emergency order should be put into place. And then if it is put into place, I would like to devote some time to what visitation should look like. Okay. And let's, in the meantime, I don't think there's any, Ms. Woodruff, are you able to accommodate at least telephone communications?
Yes, I offered to have a 4-hour visit this afternoon, which she has not responded to me on, Your Honor. I'm doing everything I can possibly.
Okay. So it sounds like Mr. Anagnosto, if you just want to let your client know that if she's looking for that informal visitation between now and when I issue a formal court order, just to, reach out or respond to Ms. Woodruff. Okay. All right. I will get that emergency order extended through the date of our hearing, August 22nd, 10:30 a.m. We'll address both the order and visitation. Let me go around and see who we have present.
I was not aware that I was appointed to that case.
Oh, you were not?
No, I'm on here for another matter.
well, then maybe that's why I was surprised you logged in, because I was handed an order this morning appointing you to this case. So here's my thought on that. Mr. Gojak, I believe that the court had appointed you or was wanting to appoint you on behalf of the mother, Melissa Warden, based on her request last time.
Well, actually, I do apologize. Yes, I was aware of this case. I just didn't have it on my calendar for today, and the name is familiar.
Okay, but that's understandable because I will tell you that I was just handed the order to sign this morning, so you would not have notice of this. Here's the other hiccup in this case for the parties that are present. We have no interpreter. We've always had an interpreter for this matter. I reached out to my judicial assistant who said for whatever reason, we don't have an interpreter available. So regardless of everything else, I can't move forward on this case today anyway. So my thought is that we will simply be setting a new date for the parties.
Excuse me, Your Honor.
Yes, and tell me who's speaking.
My name is Erendira Hernandez, and I am the daughter of Carolina Hernandez.
Yes, and I've met you before, and the conversation we had is that for formal court proceedings, I do have to have a court certified interpreter for the petitioners. I can't rely on a family member interpreting.
Okay.
Okay. So you go ahead and let them know that. That's fine.
Okay. Le dijo que básicamente no vamos a poder continuar hoy porque la corte no tiene un intérprete y no me pueden aceptar a mí
Also
como
let them know
intérprete
that
porque
the
necesitan-
mother, Melissa Warden, has just now been appointed a lawyer.
Okay. I was interpreting while you guys were talking.
Okay.
So they already know.
Okay. Do we have Melissa Warden with us? Does not look like it. Okay. So what I'm going to do today is extend the emergency order just through the date of our next hearing.
Okay.
And do my best to make sure we have an interpreter at that hearing. And that'll obviously also, I'd like to give Mr. Gojak time to meet with his client and be prepared. How much time would Mr. Gojak would you want for that?
Your Honor, maybe a 2-week set over, that should be sufficient.
You think 2 weeks would be sufficient?
I would think so.
Okay.
I mean, I'll know very shortly whether I can get a hold of her.
That makes, go ahead, ma'am.
Can we we can't go over anything of the case, or can we at least tell you our attempts to try to we have some information from what has happened since the last court date.
Right. So we have an attorney now appointed to Ms. Warden, but she has not been given that opportunity to meet with him yet. So I would not be taking any sort of testimony in this case. Essentially, I am finding good cause to continue the entire matter to August 22nd, which is 2 weeks from today at 10:30 a.m. Are you available at that time?
Yeah. Okay, August 22nd is fine.
Okay. And then you can let them know that will be the date, hopefully through an interpreter, that they can give testimony to me about their concerns, questions, et cetera, in this case.
Oh my God. No sé qué hacer.
No, pues ya tiene el abogado y ya que él se encargue de entregarle, pues hemos tratado de una manera de dárselos, pero no podemos.
Ya, pero también no es justo que no podamos hacer nada porque no tienen intérprete, pero me tienen a mí, no me quieren usar.
Pues sí, pero pues son las leyes. Hay que acatarse a las reglas.
Any questions for the court?
No.
Okay. We'll see all the parties back on this matter, August 22nd at 10:30.
Okay, thank you.
Okay, thank you.
Thank you, Your Honor.
Thank you. You're here as purporting to be a witness, or what's your?
Yeah, just family together.
Okay. And then Ms. Trimmer, is this the same for you, a family member?
Yeah, I actually have Ray Wing. He's the father of Rex on the phone from the jail. So he wanted to call in and he was unable to. So I'm
Okay.
also, yeah.
Which jail?
Clark County.
Oh, yeah. Okay. We can't
Yeah.
contract with them for his appearance here. Okay. And then Ms. Williamson.
My name is Sarah Williamson and I am Savannah Bragg's sister and I'm here in support of Christy.
Okay. Cassidy Williams.
I am Savannah Bragg's sister and I am here for support of Christy.
Okay. So here, yeah, and Ms. Farr. Yeah. So, and I see you there. Thank you. So this is a case where it appears as our bench has signed an emergency order. However, it has subsequently come to our attention that there's a dependency proceeding involved that neither petitioners nor respondents notified this court about. We are aware of it now. I have been in contact with the dependency judge. I guess what I'm going to do right now is put in the waiting room all of these folks who are proposing to be here as witnesses. I'm not going to be taking testimony on a case that is in a dependency proceeding. Ms. Trimmer, this is highly unusual, but I will leave you in the Zoom courtroom just because you do have Mr. Wing on the line. That's not my typical protocol, but this case is unusual enough that I am going to allow it. But if you have identified yourself as a witness, I'm putting you in our waiting room so that I can talk to the actual parties involved in this case without your presence. So if you see a note that you're being put back in the waiting room, that's why. Okay. Give me a minute to get this done.
Your Honor, real quick, I don't think I addressed myself. I'm Carrie Ashley. I'm the primary assigned social worker with DCYF, so I'm not sure if you want to keep me in or put me in the waiting room.
Nope, I absolutely want to keep you in. Thank you for identifying yourself.
Yeah, thank you.
This case ended up with a very large Zoom screen, so apologies for missing you. We'll keep Savannah in. The 5818 is a witness. So I did speak with Judge Scudder this morning about the unique scenario this case finds itself in. So perhaps, Ms. Buck, let me just first ask you, I assume you were aware that this child is in a dependency proceeding.
I was given guidance from two CPS caseworkers to file for guardianship. I filed for guardianship and I wrote in there the DCYF case number and the caseworker on the case. I am not a lawyer. I do not know the law. So when I was told to do that, I don't understand. I didn't do anything that I wasn't advised to do.
Okay. Let me turn to Ms. Ashley and Ms. Reese, whoever wants to go first. What's the state's position on this case? And I'll tell you, just in my discussions with the dependency judge, there was kind of a little bit of back and forth about how to proceed on this minor guardianship case today. So I would love to hear your position.
Absolutely. What I can tell you is Miss Reese and I were just recently assigned to this case as of last Wednesday. So this motion was filed prior to that. And in discussion with our AAG, and just given, like you said, the unique nature of this, right now, what we're seeing is that the dependency matter and where the kiddos are placed currently can be better managed within the dependency court, at least moving forward. I know that was kind of vague, but it's been the nature of things the last few days since we're just trying to get all this sorted out.
Yeah, kind of.
But we don't have a real good assessment on things right now.
Okay. Is there a current, and I tried to log in this morning, but I don't want to overstep my bounds with juvenile cases. So I don't have full access to what's been done in the dependency matter. Is there, let's say, for sake of argument, if I didn't re-up the emergency guardianship order today, where will kiddos be?
So as of Monday, the department motioned the court for a change of placement. So we have 4 kiddos involved. Is this only as to Rex and Renzi?
This is just Rex and Renzi.
Okay, so those 2 are placed with Miss Buck at this time.
Okay.
And that was approved yesterday in court.
Okay. So it sounds as if we are not extending the emergency order, and Ms. Farr, I had assigned you to this case at the last hearing, correct?
Yes, Your Honor. And
Okay.
I can tell you, I spoke with Michael Rothman, the ATG, and
Okay.
he said that the department will not be relinquishing exclusive jurisdiction in this matter.
Okay. So I think the only thing, I do think that the dependency court has exclusive jurisdiction. What I'd like to do is set this over, instead of dismissing it outright today, I'd like to set it over 1 week so that I can actually have a conversation with the dependency judge to make sure that's the direction he wants to go. We had a 30-second conversation in the hallway. He's on another docket. But my decision today will be, Ms. Farr, we can't, I think, terminate the order appointing you in this matter, just so you don't waste time and expense on it. And then I am declining to reissue the emergency minor guardianship order, the immediate, so that will terminate in this case today. I would like to set this on for a review hearing next Tuesday, just to see at that time if it's proper to dismiss the case outright. And I believe that's the direction this will go, just as a heads up to everyone. But out of an abundance of caution, I'd like to just talk to the dependency judge. Does that work for the parties?
Yes, thank you, Your Honor. Yes, it does.
Yes, thank you.
Okay.
And Your Honor, if you would just enter the order terminating or vacating the order appointing me, I'm not going to charge any fees in this.
Oh, okay. Are you sure?
Yeah, it
Okay.
was just a couple of phone calls. So
Okay. Well, I appreciate your reaching out to Mr. Rothman on that. I will issue that order vacating your appointment then. And then on behalf of the state, Ms. Ashley, Ms. Reese, does that sound like an acceptable plan for the state at this time?
Yes, thank you.
Yes, thank you.
Okay. All right. That's how we'll proceed. Any questions for me? I'll say, Ms. Bragg, I do see you there in the chat stating that you object to the emergency order. What I am saying, my ruling today is that I'm not extending the emergency order. I don't believe this court has jurisdiction right now to do so. So all other than our review next week for dismissal, all further proceedings will be done under the dependency action. Okay. All right. Well, thank you, everyone. I appreciate your input on this case that got a little bit complicated.